exceptional, and also the methodology that I'm using, because this is more a philosophical argument, but I warned Rivi that this is going to be the case, so she took the risks. So you will have to suffer. So very often we ask the question of whether people have an obligation to obey the law, or at least a reason to obey the law. And this paper, which is a joint paper with Vincent Chow, who is a criminal law professor, we ask the contrary question. When does a person have a reason to disobey the law because it is a law? And philosophers who have considered the question of disobedience typically say, okay, we have a reason to disobey the law when the law is unjust. In this paper, we argue that there are content-independent reasons to disobey the law, namely reasons that have nothing to do with the justice of the law. So even when the law is not unjust or illegitimate, there are reasons to obey the law, to disobey the law. Our argument is based on the following intuition, the following claim. Very often, or typically, the law makes inflated claims concerning its authority. The law requires us to submit to it independently of the content of the law. So even if the law is always just, there is always a possibility that there will be something new or some new norm that will be unjust. And the intuition is that when a system of norms, or when somebody makes a claim and says, okay, brush my shoes or something. So I can say something like, okay, if you ask me, perhaps you are disabled and you cannot do it, I would have done it. But because you claim you have an authority over me, I'm not going to do it. This is an intuition. And what we are arguing there is that the law makes precisely similar claims. It makes a claim that we ought to obey it, and therefore that we have a reason to disobey the law because it is a law. Of course, it's not conclusive reason. We don't, or we ought not do it always, and so on and so on. But this is an intuition. This anti-authoritarian principle, I think, is grounded in the virtue of what he calls the civic integrity. Namely, the virtue of clearly communicating our political conviction or commitments. By disobedience, we communicate the conviction that law makes inflated or too broad claims to authority. We show how our account of disobedience is distinct from other theories. In particular, we also claim that the new movements of disobedience reflect this intuition. A specter is haunting the globe, the specter of massive disobedience, from the umbrella movement in Hong Kong to Occupy Wall Street, Black Lives Matter in the US, COVID protests in Canada and Europe. Numerous people and organizations engage in massive disobedience. The current theories of disobedience are old ones. It's basically evolves from 1970s and so on, the Vietnam War and so on and so on. And legal philosophers often ask when we have a reason to obey the law as such, simply because it is a law. As I said, we ask the opposite question. When do we have a reason to disobey the law because it is a law? We first show that the law necessarily claims more authority than it has. And second, we argue on the basis of civic integrity, that is the virtue of publicly standing up for one's principle, that citizens have a reasons to disobey. And I think the figure that basically represents our intuition best is a figure that does not appear in political philosophy, but appears in literature, in the culture in general. And that's the figure of the rebel, disobeying a legitimate law. If a person who has no authority over me, claims to have authority, purports to issue orders, I am resentful and I want to say, no, you cannot do this. I will not act in accordance with your orders, not because I disagree with them, but because you order me to do so. In reacting to such an order, one may make the following claim. Are you ordering me to do X, or are you requesting me to do X? I am willing to do as you request, as long as it is a request rather than a demand. The pretense on the part of somebody who has no authority to issue orders seems to be a rebellious sentiment. Let me now start with showing that the legal system makes inflated claims to authority. Most contemporary legal theorists believe that law demands broad and powerful authority, and sometimes unlimited. In the paper, I bring a lot of citation to this effect. Here I'll merely cite Hart. Hart presents a particularly clear version of this view when he says that commands, including legal commands, are intended to preclude or cut off any independent deliberation. Raz argued that commands are not intended to preclude deliberation, but claims that the law demands obedience. Because he cares not about what the subject thinks, but how he acts. Following much of the literature, we suggest that law demand for obedience exceeds law legitimate authority. And thus, law's claims are inflated. Law claims more authority than it has. The consensus view is that the law does not bind without remainder, meaning that law subjects always possess, as it were, normative breathing room to judge for themselves. Taken together, the consensus view seems to be that while law purports to command preemptorily from a citizen point of view, its commands are at most pro tanto commands, mostly just reasons, but they cannot preclude other considerations. Consequently, an anti-authoritarian would resent being ordered to do X, even when she has a reason to do X, when this is presented as an order, as a command. Can we justify this resentment against command? Can we say something to justify? Is it rational to say, I don't do it because I was commanded to do it, not because I don't want to do it, not because had you requested me to do it, I wouldn't have done it, but simply because you commanded me to do it? We think that there are good reasons for this. And the reason, a person who believes that a person or an entity makes inflated claim to authority has a reason to communicate his commitment or his belief that this exceeds the legitimate authority. Basically, the idea is that a person ought to communicate one's political convictions. And one of the political convictions that one should have, and I think most of us have, is that the law cannot, does not have absolute authority. The law cannot command us. In other words, one of the convictions we have is that the law makes inflated demands to authority. And the way to convey this conviction is by disobeying the law because it is a law. And anti-authoritarians who break the law conveys not only that the law in question is ethically dubious, but that even a lawful authority has limits on the extent to which it can insist upon compliance. Disobedience conveys a conviction that law cannot justifiably claim absolute authority. Disobedience as such is a political act. It is meant to convey a political conviction that the law, even if just and legitimate, does not bind without remainder. That is, it cannot claim complete or too broad deference from its subjects. One might argue, look, I can just say it. Why do I need to disobey? I can just, go with a poster saying, law, you claim too much authority. Consequently, it could be argued that civic integrity is satisfied by openly asserting that blind obedience is a vice. In contrast, we maintain that citizens have a reason not merely to say that law is not ultimately binding, but to act upon that conviction. Stating this conviction may seem cheap talk. It is not sufficiently salient. It is not sufficiently serious. The only effective way of expressing this conviction is by disobedience. So this is how we resolve the apparent paradox of willful disobedience to an authority acknowledged to be acting reasonably and justly and within its jurisdiction. Disobedience as such does not necessarily require rejection of the authority normative powers. Rather, it may serve as a public reminder that no authority, no matter how legitimate and just it is, can claim the power to conclusively make decisions how a person shall act. Seen in this light, disobedience as such is not necessarily a challenge to the government right to rule. The government has a right to rule. We should also obey it in most cases, if it's a just government. Of course, it's not my government, but that's a different thing. Disobedience as such expresses and communicates the view that while the government may have the legitimate power to make laws, and those laws may come with intrinsic and instrumental reasons for compliance, those reasons do not amount to a right to insist upon unquestioning obedience or deference. Let me summarize the argument. The consensus view among legal philosophers is that while law claims to direct action in a preemptory matter, conclusive matter, absolute matter, if there is a duty to obey the law at all, it is mostly prima facie or pro tanto. Law thus claims more authority than it has. This gap supports anti-authoritarian sentiments, supports the feeling, I have to disobey because you claim too much authority. We then argue that anti-authoritarianism is not merely of theoretical interest, but generate distinctive reasons for rejecting the law's command. And this is the communicative reasons. I have to communicate, I have to convey to Amnon that I believe that law claims too much authority. Civic integrity counts in favor of publicly conveying one's considered convictions on matters of public importance. For an anti-authoritarian, a persistent failure to engage in disobedience as such opens one to the criticism of a failure to live up to one's own principle, to communicate one's own convictions. While the strength of the reason to disobey, simply because it is a law, varies by context, the phenomenon of cheap talk suggests that it is occasionally strong enough to motivate deeds rather than just words. Disobedience as such has been ignored by legal philosophers. This is despite the fact that rebellious sentiments against the pretension to issue authoritative orders are prevalent in both personal and contemporary political life. Further, the current prevalence of disobedience in different countries triggers the conviction that current theories of disobedience are unsatisfactory. After all, it is often unclear that the illegality of the protest is a good means to achieve their aim. Sometimes it's not a good means. Sometimes I want to do it illegally for other reasons, not because it is an effective way of achieving what I want. What we have argued is that even if the legality of such action is not conducive to the realization of justice, there is a reason to disobey. A distinctive feature of our account is that it identifies a reason for disobedience that does not turn on a particular view of justice, on the content of the law. The aim has been to identify distinctive and unnoticed reasons for disobedience to the law because it is a law, not because it is unjust. The reasons for disobedience as such flow from the observation that law makes inflated claim to authority. For those who acknowledge the anti-authoritarian gap, disobedience is grounded in the virtue of integrity. standing up on one's convictions. It does not turn on the quality of the law. For such a person, civic integrity requires manifesting, communicating the conviction that the law does not decisively bind its subjects. Now, to talk about it and convince Americans with respect to it, I have to cite Jefferson. As Jefferson said, a little rebellion here and there is a good thing. And we would add, it is a good thing independently of the prospects of change. Thank you very much.